At 10 a.m. tomorrow, we're finally going to find out whether Prince Harry versus the Mail will go to a full trial. Back in March this year, Associated Newspapers, which owns the Mail, found itself in court arguing that a misuse of private information claim brought against it by a host of British household names should be struck out. There was a 4-day hearing, which you might remember from the extensive press coverage at the time. Prince Harry, Doreen Lawrence, Elton John and other claimants turned up at London's Rolls Building to hear the arguments play out, and some pretty explosive claims were made on both sides. We will imminently know who was successful. The case might progress to a full trial, opening up a Pandora's box for the Mail, which has so far stayed steadfastly out of the hacking scandal that has engulfed the reputations of its fellow tabloids. Or Mr. Justice Nicklin might decide that the Mail's desire to strike this case out before reaching that point is legitimate. We'll update you when we hear more. But for now, let's revisit what happened in spring this year. I'm going to take you through some of the more complicated legal arguments because there's a lot of important stuff couched in the specifics. First of all, we now know a lot more about the details of the individual claims. Taking a step back, the kinds of crimes we're looking at include accessing private financial, medical and travel records, bugging cars and homes, paying police for information, and the interception of phone calls. In Doreen Lawrence's case, this happened while she was working with the paper in pursuit of justice for her son, Stephen. One of the things the Mail allegedly did was monitor her bank accounts to see if she was working with any other papers at the same time.
Well, that is just extraordinary. The Daily Mail is so close historically to Doreen Lawrence, having published a front page about her son's case. Now she is turning on them and accusing the Daily Mail of spying on her. Doreen Lawrence suing the Daily Mail gives another incredible twist to the story of one of the most torrid and awful murder stories in the UK. The Mail was the newspaper which published the famous Murderers front page. It accused 5 young men of murdering her son, Stephen Lawrence, at a time when they hadn't been convicted. It said that they were murderers and defied them to sue. It caused a sensation at the time. But for the Mail, this is terribly important because it's a paper that is often accused of racism with often good cause. But it holds up the Daily Mail front page support for the Lawrence case and its intervention in the Lawrence case as a model of its journalism that stretches beyond race. And it's a justification for the kind of paper that the Mail is. And yet, it's not a justification, it's a hollow story. And the fact that Doreen Lawrence is now suing, she has always kept pretty quiet about the Mail. It's been a kind of frosty relationship at times, I suspect, but she's always kept pretty quiet about the Mail. Even, she's a Labour peer who campaigns on race issues. She's not taken the Mail on head on, so far as I'm aware. Now she's taking them on her own case, and she's accusing them basically of spying on her. Now that's absolutely extraordinary. The timing of this, we don't know the details, but the timing of this is almost certainly falls in with the other cases, the years about 1996, 7, until perhaps 2010, 2012 maybe. Now, falling in that period, this was the time when the Mail said it was supporting the Stephen Lawrence campaign, the campaign to bring his killers to justice. Spying on his mother, who herself had become a very prominent and extremely highly respected personality. That was really, it's a very, very dangerous case against the Mail.
Have a read of Brian Cathcart's series of articles on Byline Investigates for much more detailed summary and analysis. The bulk of Prince Harry's claims relate to the tracking of the whereabouts of him and various ex-girlfriends. He alleges that the Mail hacked a phone call he had with William concerning the publication by another newspaper of a photo of their mother, Princess Diana, as she lay dying. Elton John and David Furnish talk about medical blagging that went on around the time of the birth of their first child. They alleged that the male obtained and published the birth certificate of this child before they had seen it themselves. Elizabeth Hurley claimed she was illegally targeted while pregnant and just after the birth of her baby. She says that the male got hold of her financial, medical, and travel records. Her phone was tapped, she had a mic planted on her window, and her ex-boyfriend Hugh Grant's car was bugged. Sadie Frost says that she was targeted while she was getting a divorce from her then-husband Jude Law. Covert illegal methods were allegedly used, and she says that she was left feeling suicidal. The address of Lib Dem MP Simon Hughes' lover was also apparently tracked down illegally. Even beyond the underhand methods that were allegedly used to get the information in these articles, the content of the articles themselves speaks to a callous approach to personal tragedy and issues like race and sexuality that arguably permeates the Mail's reporting to this day. A&L firmly denies all of these allegations. A&L started out by arguing for temporary anonymity for the journalists and executives named in court documents, on the basis that they deserve the right to a fair trial. There are usually few reporting restrictions in civil litigation because of the principle of open justice and because there's not usually a jury. It's thought that the judge is professional enough not to be swayed by media coverage. The rest of the hearing was concerned with whether the case should advance to a full and public trial, as the claimants want, or whether it should be thrown out beforehand, as A&L want. The basis of its arguments are as follows. 1, that parts of the case should be struck out because they rely on confidential documents, and 2, that the whole case should be struck out because it is related to events from too long ago. On the first point, A&L's lawyers say that a document forming a crucial part of the claimant's case was handed over to the Leveson inquiry on the condition of confidentiality. They argue that this could only have been accessed illegally and that it therefore can't be relied on in court. The document in question contains details of A&L's dealings with 19 private investigators. It includes information on the journalists who commissioned them, how much they paid them, and so on. With this proof that they were used, the claimants hope to confirm that private investigators were breaking the law in terms of what they did. They deny that the document is truly confidential. Now to the main event. Should this case go to trial at all? Normally, with privacy cases such as this one, there's a 6-year time limit. But you can get around this in exceptional circumstances, such as if you didn't know or couldn't prove what had happened. For context, there are numerous cases involving the Mirror Group, a news group, progressing through the courts at the moment. Historically, they've been allowed to go forward in spite of this. Recently, however, parts of a case brought by Prince Harry and Hugh Grant against Rupert Murdoch's newspapers were struck out. It was argued that they should have known more about voicemail hacking specifically, which occurred more than 6 years ago. On the other hand, last year, news group's request for a cut-off date for the claims was rejected. In their defence, A&L referred to the claimants saying they were suspicious and paranoid about Mail stories for 10 years. They also say that the new evidence that has emerged is vague and not likely to actually convince a court. Mr. Sherborne questions how the case could have been brought earlier when, as a result of the defendant's deliberate concealment and the intentionally covert nature of the underlying acts themselves, the vast majority of the evidence is necessarily in the defendant's own possession. It's an interesting one from A&L because they have always categorically denied carrying out any form of unlawful intelligence gathering. However, at the same time, they're saying that the claimants should have had suspicions for many years and should have acted on those suspicions previously, ignoring the paper's denials. Prince Harry, Doreen Lawrence and the other claimants are saying that they acted as soon as they possibly could have. So there you go. That was our recap of what happened in the 4-day pretrial hearing between various claimants and associated newspapers back in spring this year. Mr. Justice Icklin reserved judgment and is due to report back on his findings tomorrow. In the meantime, let us know what you think in the comments. And if you would like to support our work covering the press intrusion litigation like this as it moves through the UK courts, please consider subscribing to our Patreon.